I see we have a full house. Good morning. For those of you who've never been to Lexington County, welcome to the Lexington County Courthouse. Are you ready to call? Can you call it? Give it right back to me. All right, we're here for a status conference. I'm going to get the clerk to call the case, please.
In the matter of State of South Carolina versus Richard Alexander Murdaugh, indictment number 2022 GS 15 00592 through 595.
Thank you. All right, Mr. Waters, how are you?
Good morning, Your Honor. Good to see you.
Good to see you. Now, let me ask you, I know some of your counsel at the table, but I don't know all of them. Can you please just let me know who the state's team is?
So I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka, who is
I
here.
know.
We have John Metters as well.
I know Mr. Matters.
And see, Your Honor. You may see at various times we have Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
All right, welcome. Let me, Mr. Harpootlian, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
Please report, Your Honor. This is Jim Griffin.
Mr. Griffin?
Bill Barber.
Mr. Barber, good to have you. Okay. All right. I've made some notes on a status conference, and I'll let y'all talk in just a little bit. But I want to go over what I want to go over. Because I want to make sure that all the discovery in this case is complete. And I made some notes, and let me tell y'all, I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions, video recordings, whether there's ballistic, firearms, are we complete in that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, and formerly being an attorney and that sort of thing. So it's my understanding, complete extractions were provided to them, whereas the prosecution team, the investigative team, only received the privilege review cell phone extractions as it relates to his phone and that sort of thing. As always, we are constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive productions that were made, not only from just the murder investigations, but also from the very extensive state jury investigations as well. So he has provided those, and obviously I'm not aware of anything in the categories that you mentioned that have not been provided to me.
And not anything that needs to be reanalyzed or anything that the court would be waiting on?
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night to the defense motions that were filed late last week. Came in the office Sunday to write those. One of those is their request for independent testing on DNA. As we put it in our motion, and I actually got an email from Mr. Griffin this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're proposed to do, happy to facilitate those conversations and discuss those with the defense and then with Your Honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those to the court.
Okay. All right, Mr. Harpootlian or Mr. Griffin?
Your Honor, I want to address everything but the DNA issue. I'll let Griffin talk.
Right, I'll talk about the DNA later.
So we don't know what we don't know. And I'll give you an example. Let me hand this up to Your Honor and hand copies to Your Honor, this is a transcript of an interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, processed the scene, and were very involved in the forensics of processing the scene. And if you go to page 6, Chapman, who's in charge of the scene, says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to a question, I believe he had some help in the aftermath. For Rutland, yes, Captain Chapman. You know, the disposal of weapons, the moving around a vehicle. We heard so much about SLED and AG's office, and they don't have anything. It's all circumstantial. So I pose this question to you. It was a clean crime scene, staged crime scene, clean crime scene. Would you expect to find more evidence or less? And that's what's kind of hard to get people to understand is we didn't find a lot. But why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other people at the scene. That he had assistance under their theory, or there were other people there. We need to have that furnished to us. And we have other witnesses that testified at trial who are saying something totally different, indicating there's evidence to believe that somebody else was at the scene, or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene, along with Rutland, who processed it that night. We need, and we're in the process of doing this, to determine if they took those statements or the reports. So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say this, and no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate anything. We don't have subpoenas. We don't have a grand jury. We don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate it? Did they investigate it? And I must tell you, there are a lot of pieces of information out there that, and maybe they just stopped once they got the conviction, didn't do anything else, that it's inconsistent with our desire to get a conviction, have a conviction held. So they didn't follow it up. Maybe it does need to be followed up, but we're going to have to go back and look at all of that. We're going to have to determine whether or not additional material was developed since the trial. And of course, all of us were shocked by the clerk of court's conduct in the trial. I know we were, I know the state was. But it's caused us to go back and look at, and we haven't done a thorough check of it, with all the testimony and read it all, not in the sense of an appeal, which we've done, but in the sense of, I mean, in criminal cases, we don't have depositions. We don't have them here. We have a transcript of every, but not every, I'm sure they're gonna get rid of some of these witnesses that are horrible first time around and get additional witnesses. But most of the witnesses, we have their transcript, their deposition. We need to go back and read all of that, and we need to get a sense of how you cross, just like you would in a civil case. So I can't say that we've got it all. I can't say that we don't have it all. Again, I don't know what I don't know, but I think we will be very diligent. And one of the other things we talked about is Murdaugh's access to that information in a way that makes it convenient for him and doesn't inconvenience anybody else. We'll talk about that. That's another motion. We'll talk about that.
I'll get to your motions in just a little bit. What I really want to know is about phone records, text messages, cell phones, video recordings, toxicology, fingerprints. You have all that discovery.
We're not sure, but we need to review it as if we were getting ready and brand new. I can't, just because we looked at it 5 years ago, 4 years ago, doesn't mean we know we have it. We'll be diligent in doing that, but certainly I would think it'll take us some period of time to review that.
Yeah, no. I'll start out in during the trial.
Right. One other point, reminding me, we did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the Attorney General's fault. That is GMC's fault for not furnishing it. We had to do that on the run. We want to go back and analyze that and have an expert analyze that even more. I do want to emphasize the Attorney General got it at the same time we got it. No inference to anything improperly.
Okay.
So that's part of what we need to do. We need to hire additional experts based on some of the views we now have on some of the witnesses, both the state and the defense have. And they need to examine those reports to determine whether we have it. So it's going to take a little bit of time, Judge. I can't tell you today we have everything because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Well, yes, ma'am. So, Your Honor, we actually SLED had sent 2 search warrants to GM well in advance of the trial, and we're told we ain't got any. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry data, which of course was all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, you know, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to a usual form. They assisted and agreed to go forward because we each had our theories about what had to happen next. So that was nothing with the fault of the state, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. As to him saying, we don't know what we don't know, well, I know my obligations are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, I mean, we're always constantly auditing that and doing our obligations, but I take discovery obligations very, very seriously. Mr. Harker knows that. As far as these musings, I haven't watched this TV interview. The musings of some captain about, whether the scene was clean. Well, there was evidence presented at trial that there was standing water on the concrete pad of the kennels, that the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of the kennels. So he may have been talking about that, but ultimately, while Colleton responded initially, the scene actually was in charge of the process by SLED, and they've had access to all that information. So to sit here and imply, we don't know what we don't know, well, I'll recognize that, but I know that my obligation is to provide that information to the defense. And if I'm aware of it, then it's been provided. And we have done that. They've had it since well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts and was immediately disclosed to them. They had every opportunity to process that information, and then they agreed, you know what, let's continue on. So that's not any sort of indication of a bad process or prejudice on both sides.
So the bottom line is they have everything that you have.
To my knowledge, yes, ma'am, and we were very careful about going through all that discovery.
And you don't know of anything else that needs to be analyzed at this time?
Well, again, we have that DNA.
The
issue.
DNA, and I'm going to get to DNA in just a moment.
Of course, it was analyzed ahead of time. Now, what
Right.
they're talking about is some additional capability, and as I expressed in our motion, and Mr. Griffin has responded, I'm happy to facilitate discussions, and if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Now, of course, as we put in our motion, ultimately, there's absolutely no evidence that Maggie Murdaugh was in a struggle with anyone, that she had any sort of defensive wounds, that she was scratched any sort of attacker. And we also know that it's very common with how sensitive touch DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring, but that doesn't mean that we are not willing to discuss with the defense anything that they want to do, and if reasonable, we'll be the first to do that. And if there's any needs to come back to this court, do that as well.
Okay, thank you. Sure.
We know from testimony in the first trial that the chief SLED officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No longer SLED, but it raises questions with us, not whether it's been withheld by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the subsequent case after the trial where he had evidence? And I think we've got to go through it and look and say, are there gaps here? Are we missing something? And for us, and look, we want to try this case as quickly as possible. No question about it. But what we don't want to do is not be prepared based on what we now know happened at the first trial. And we'll have a motion probably next week that will expand on that a little bit. We didn't feel that we wanted such a motion.
Well, and I don't. I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pretrial conferences, and I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive, that I could go ahead and rule on those today and be done. And I will set up a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. I don't know that one pretrial is going to do it for this case. We'll probably have several. And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpootlian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay? All right, so let me move on to my next notes. And we've kind of touched on it a little bit. Experts. Do you know how long? And the reason I'm just asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody who knows me knows that I will move an old case. And I intend to do that with this one. So, I'm asking Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
Yes, ma'am. So the vast majority of our experts will be with SLED. And so I think that, we are ready, within reason, of course, to move this as expeditiously as possible. We do have another expert that testified from the FBI and things like that, but much of that is the same. And so, as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this, before the end of the year, like towards the end of the year, we're ready to go. Put it together about that. And so, I'm not aware on the state side of any expert issues that provide for additional delay.
All right, Mr. Harpootlian, how about for the defense?
Your Honor, we have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, when we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. And Mr. Griffin will address the specifics of that in just a moment. But to try this case this year, these guys are talking about going to the death penalty 4 months ago or 3 months ago. To try it before the end of the year cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't try it next year. If we have to go down there and take in a banker's box at a time to read documents, almost 20,000 pages of documents. So we came up with a way to expedite.
Well, surely, Mr. Harpootlian, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the material was on. I mean, it's ridiculous to require him, not with all due respect, to require him to have a memory of each document that he looked at almost 5 years ago. And by the way, our solution to that, contrary to what Mr. Waters put in his motion, is ironclad. There's no chance of it being distributed. We'll give him a laptop that's encrypted, since there's no attorney-client on it. Corrections can look at it. SLED can look at it. Anybody can look at it. And let him look at that without us having to take hard copies of stuff down there and review it with him. Can't leave it with him under the court order. In other words, you just can't take him to discovery and leave it with the court order prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his. But if we have that, and he could be reviewing these documents and experts as we're reviewing them. I mean, let's not forget, he's a lawyer. Now, he's a disbarred lawyer, but he has probably more trial experience than many of the folks on either side of this court. So he understands what he's looking at much better than any client I've ever had. So I think it's important, if you're going to try to expedite this, for him to have, and we can talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks retained, have them look at the adequate material, look at the state's testimony the first time around, and of course if they have a change in who they're using or taking a different approach, we need to know that as soon as possible. I would point out that they were giving us discovery in the last case after the first week of trial, in the second week of trial. So we can't have that happen again. They say they've got it all. We're going to assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to try. I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. And what we're comfortable with is late spring, early summer next year.
Okay.
We can live with that. Given, I mean, if we have to go down there, one of us has to go down there 5 days a week, and we know we're incarcerated on one now, so there's 2.5 hours from here. It's a half an hour to get in. So before you ever even see it, it's 3 hours. And then you only have 3 hours with them, and then it's a 3-hour trip back. That's why the laptop is so important.
Okay. Mr. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can talk more about that. But when I mentioned that, they were asked, how soon do you need it? And I said, well, hopefully we're looking at a spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are the...
I'll get to the DNA in just a minute, and then we'll go forward on that. All right, let me talk about this computer at the Department of Corrections. I did receive your response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpelian? I mean, basically, I just made myself some notes. You were concerned about the state grand jury material and talked about a protective order and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case. It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to that, Mr. Harpelian?
Your Honor, the issue of that is what is the state grand jury material? I think, you know, if we can designate what that is. It's beyond grand jury testimony, which is, there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, you know, underlying records and whatnot. And so, you know, is that really sensitive grand jury material? And some of us introducing evidence at the trial, I'm sure of that. But, so, no question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of the subpoenaed documents and information have been produced.
And Your Honor, if the issue is dissemination, I mean, he has a right to read it.
Oh, absolutely. I said that. It does not prohibit him from reading it.
The issue is dissemination. I mean, we're just basically talking about a big Kindle. You can read on it. You can't send emails. It's not connected digitally or cell or Wi-Fi to anybody. It can be kept. Let me say this: the Department of Corrections has been extraordinarily professional in dealing with us, giving us access to them. But no complaints with them whatsoever. But what we'd like is we'd like that laptop with the warden and corrections to have total access to it. It can be inspected by SLED to make sure it can't transmit an image, a message, can't be used in any way. There is no Wi-Fi at this particular institution, so it has to be by self-service. I mean, these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's a 1% of what we want him to look at. And we can certainly do that separately with hard copies. We'd be happy to go down there and do that.
Well, let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing reversed about that. But necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to the murder. So it was much bigger than they say. You know, I don't have the number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas, and so all of it's within that ambit. And as well as Judge Newman issued a second, to my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all blend together. And so all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member through the defense to him, found by guys. And so this is not a guy who is, and this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down and made to safe and reliable. I understand these issues very well. The state grand jury made a point to partner with SCDC to fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue, and no matter what protections are put in place, there's always ways around those, and SCDC has experience with that. So the fact remains is he's an inmate, and SCDC is adamantly opposed to there being some laptop that he has access to. And for this idea that SLED is going to be able to review, attorney communications and work product on that, I don't understand how that's going to happen. Now, SCDC is happy to accommodate and to any meetings they have. And no one says that the defense can't bring down digital evidence to review with them while it's under their supervision and then take it with them when they leave. That is absolutely the way it should be, that ultimately this information, whether state grand jury or not, is too sensitive to have an inmate, despite what protections are put in place, have a laptop, because frankly the reality is inmates are constantly and successfully violating whatever protections. Despite everyone's best efforts, you're doing a great job. It's just a natural.
Okay. Sure.
I had a series of emails, and I don't see the Department of Corrections here today objecting. I had an email chain with the warden at the particular institution, and he doesn't raise those objections. He just, and we will bring in another laptop with can't cellular or Wi-Fi capabilities. So, and that's what this says. So, and with all due respect to the Department of Corrections, if we don't get the ability, I mean, if Mr. Griffin and I, or Mr. Barber, or Ms. Fox have to go down there, 3 hours down, sit with him for 3 hours, 3 hours back, we're talking about at least the end of next year, if not the beginning of the following year, to get this support. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a laptop that doesn't have any capability to communicate or copy. And we'll be happy to have SWED inspect it. We'll be happy to have the Department of Corrections inspect it. But the idea, we bring laptops in. We were given, as you can see, permission to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it, or some office at the institution keep it, and give it to him when he needs it? And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Waters' job to legally prejudice the defendant, but this is beyond the pale. This is beyond the pale. I'd ask you to remind Mr. Waters that he has an ethical duty to see that justice is done, not to get a conviction. Thank you.
Mr. Harper knows me better than that.
I don't.
And that is,
Okay, we're not going to go there.
and I have no intent to prejudice anyone. Prejudice suggests a decision on an improper basis.
And the court doesn't take it that way, Mr. Waters.
Thank you, Your Honor.
All right, let me tell both of you. I took the liberty of calling the warden and talking to him about the laptop situation. And because I too used to practice law, I remember terabytes of discovery that I had to carry to my clients to go see. And I know that it can be cumbersome, and I would imagine the discovery in this case is a lot. How many pages do we have, Mr. Waters?
It's very extensive. It's half a terabyte.
Half of a terabyte, okay. I talked to the warden. He will not allow a laptop, and for safety reasons. He said he would, quote, make available a conference room. Counsel may bring their computer. They could have a law clerk come, or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. No other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpootlian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop computer in his cell. It's for safety reasons. That's out of my control. I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety. Okay?
We're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room as he would with us to look at it there. Does that make a difference?
Well, I'll ask him. But when I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally. Okay. We'll follow up on that in our next pretrial. Or if I can, I'll probably let you know before pretrial. But if he says no and it's for security reasons, then the answer is no. I'm not going to allow it. Do you understand, Mr. Harpootlian? Mr. Waters?
Law clerk or other person, paralegal?
He'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said he's not going to limit you to 3 hours. They can stay 8 hours if they want. He will make a conference room available so he could see the material. It does not have to be a lawyer. Okay, that.
Your Honor, I spoke with the director of Federal Counsel this morning, and they expressed the same thing. We're here to facilitate the defense doing that.
Right. You know, I want him to have all his discovery. He's entitled to all of it. You know, it's safety concerns. It's. If you can have a law clerk or a paralegal go down, then you're satisfied, Mr. Harpootlian. That'll help you out.
Dramatically, we're not limited to 3 hours. It makes that 2.5 hour trip down and 2.5 hours back worthwhile.
Okay. Well, then I will verify that and send y'all an email tomorrow on that. If that's okay. All right. Perfect.
Thank you, Your Honor.
All right. Now, let me go through I had a motion filed for the defense, and I just want to put this on the record. The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpootlian where he withdrew that motion. That still stands, Mr. Harpootlian?
Yes, Your Honor, although we may renew the motion, the reason for this is potential jurors are watching this right now. It's going to be, wherever this goes, it's going to be difficult to get a jury. And to the extent that parading him around in a jumpsuit shackled like an animal impacts their view, it's going to make it more difficult for us to get a jury. Now, again, Mr. Waters' argument is specious. He's not dangerous. The only thing he can convict of is stealing money. Now, Judge Newman let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is one that prejudices our ability to get a jury. So I would ask that he be allowed to come in the courtroom unshackled in, I will call them street clothes. Now,
So are you renewing your motion now?
sure.
Just want to make sure.
What I wanted you to see today is this. I mean, chained around the waist, chained with the hands, chained on the feet. I mean, this guy's not a serial killer. He's not, Ted Bundy.
You could sit down, Mr. Murdaugh.
And always convicted. He's accused of killing his wife and son. But he was accused of killing his wife and son, and Judge Newman allowed him to come unshackled in his street clothes to every hearing he had.
All right, Mr. Waters, I did read your response, but I'll be happy to hear anything, and I'll take it under advisement.
Well, again, they withdrawn the motion, and now they.
Now they,
Again, this goes back to, it's not the state's fault. He's an inmate serving a 27-year sentence, okay? This is, again, SCDC's policy for a non-jury court to have him be dressed out in restraints. He's not only facing 27 years, but an additional 40 years in federal court, and then he's also indicted for a double murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals in any escape attempt is to become unrestrained and in civilian clothes. So I'm here to represent what is basic policy and procedure for inmates serving long felonious sentences with SCDC. I completely understand that when we have a jury, the calculations are different, and that is going to be a different thing to do. The remedy for all of that ultimately is a 4-hour process. It's going to be jury selection, and it's going to be instruction from the court, which the jurors are going to follow, and which I know our citizens can.
Okay, thank you. All right, I'll take it under advisement, and I'll issue an order on that. Let me move on to the DNA. Again, I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pre-trial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received the VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now, that I've been interfacing with, and they will be better able to answer specifically how long it will take. We've agreed to pay for it, and just background information.
I'm going to let you pay for it.
Yeah. And these murders happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year, in 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberger. That's how they solved the Moscow murder cases, was through Othram lab. The difference between, and they say they don't have enough samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses an analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that, and so, you know, we're going to have to see what the lab says. They've asked me to get information from SLED as to, you know, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd asked Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around the country, and they are they're certified. They work with law enforcement. I don't know that they've worked specifically with SLED. They're familiar with SLED when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send. That
Correct.
They could send.
And they can work with the extract that SLED used when they did their STR analysis. They can work with that out there. They told me, but
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities and proposals are and any procedures. And I'm then, once made privy to that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back before Your Honor. That's precisely what I put in my motion is let's talk to let the experts talk so that my experts can hear, you know, what it is that they propose to do. And I'm happy to consider.
and I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alec Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential, and that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, innocuous. We don't know, but it's worth looking into.
Okay, I haven't said no. This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial. Anything, Mr. Waters, you're going to give them the name of the person that SLED that he can get in contact with. Let's see if there's a viable sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But
Right.
they work with a lot less than
Okay.
SLED.
Well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward, and we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away. All right. Let me move on to the motion for change of venue. The defense filed a change of venue motion. The state has not had the opportunity to answer yet. So I'm going to give them time. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions, and then I will decide for you if we go that route.
Even in spite of the acrimony here today, the lawyers have been able to talk to each other, and we have already talked about this. I think we'll have continuing discussions, and depending on when you set your next pretrial.
An answer for me?
We try, if I don't have to keep driving down the public.
Yes, Your Honor. Of course, without taking a specific position right now, I
Right.
Mr. Harpootlian this morning that, we can kick some things around, and like you just said, if we agree, great. If we don't, then we'll force it aside.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me address, I see Mr. McCullough sitting out there, and then I also have another. They're both the same protective order, but they're wanting two different things.
Ours is not the same as this.
That's right, they're two different things.
Barbara will address ours.
Right. As far as, but I think before we go there, Mr. Harpootlian, I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Again, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities and innocence.
Right, because I did, yeah, and I did receive something from SLED, an email from SLED.
That was General Counsel Adam Whitson, who's present here today, and SLED.
Where is he? Okay, I did receive your email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay, those were all my bullet points. So let me ask the lawyers, did I miss something? Is there something you would like to add?
One thing Your Honor had mentioned is the location of pretrial hearings. And from the state's perspective, we're happy to come to wherever Your Honor happens to be and for pretrial proceedings.
Okay,
And we're more than happy to come wherever you are, although this production of these hearings might not dictate, but certainly suggest you come to a venue like Washington County, where there's plenty of room and you have an extraordinary program that's accommodated everybody.
I think they've done a really good job with security and with the press and being organized. And this is my home county. Let me just ask and throw this out there. Mr. Waters, is there any objection if we hold pretrial here? The reason being, we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington, which I would not want to do to any county. Sometimes I go to really small counties, and I don't think it would be good to hold a pretrial there. Does it suit?
I mean, from the state's perspective, and again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Office, solicitors' office, law enforcement, the court, of course, is very accommodating here. So this is certainly, I think, would be of most convenience for parties as we get ready for the trials.
Okay, it's not far for anybody to travel, Mr. Harpootlian? Okay, then I will try to make sure that when we arrange these pretrials that we will try to be here in Lexington. Anything else, Mr. Waters?
I believe that's it from the state.
Defense?
Your Honor, that's all we have, but if we could talk about that schedule for the next pretrial.
Oh, I'm getting ready for it right now. Let me tell you what I have. I've gone through my calendar. And so it's hard to get lawyers together, especially when I have this many lawyers. So let me throw some dates out to you. August the 13th and the 14th. July 29th, the 30th, or the 31st.
Your Honor, so in chronological order, the first would be
July 29th.
I'm scheduled to be out of state from the 29th through the 31st.
Okay, then let me move on to August 13th and 14th.
Your Honor, we have a mediation on the 13th. The 14th is available. Yes, sir.
14th works for the state, Your Honor.
August the 14th it is. That will be our next pretrial. Now, with that said, I'd like to have all motions by August the 7th, if I could. I like to read my motions. I like to be prepared. So if I could have your motions, I understand that some of them are late. You might think of something at the last minute, that's fine, but please don't file something at 10 o'clock at night and expect me to rule on it in the morning, okay?
I apologize for those coming in late.
No, you're fine.
I came into the office just to make sure we had something out there.
Mr. Waters, you're fine. I was not planning on ruling on those motions. Now, had I been, I might say something different, but please don't do that to me, okay? Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's usually right before Easter. It is the March. Is it the 28th? I think it's the week. It's March 28th. So I'm thinking April 5th. You know, I know that we'll have a new Attorney General coming in. Y'all, Mr. Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new Attorney General time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well. When I set a trial date, I don't do continuances. I don't do it. It better be a really good reason. So, how does April the 5th sound, Mr. Waters?
Yes, ma'am, so we'll be ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or,
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not. We're going forward.
Your Honor, we're more than happy with that. Mr. Murdaugh is more than happy with that. I just, again, DNA, really all, everything, different light, because the science in all these areas is much better than it was 5 years ago.
I understand. Technology changes overnight. Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on misconduct by clerk of court. But the Supreme Court also addressed financial crimes evidence. And depending on how much of that or any of that comes in, will determine the length of the trial in many respects. Judge Newman last time would not rule pretrial on that issue. And it is going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial. And so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during the trial, or are they going to be able to put it up. And so I'm just asking maybe some earlier date where we can have, Your Honor, address those issues.
We will. I'm just going to tell you, I like to address all pretrial matters beforehand, because when I say April the 5th, we're picking a jury and going forward. All those issues should be decided by then.
Your Honor, that's my practice as well. We filed extensive pretrial motions prior to the prior trial, laying all our cards on the table. It's exactly why we thought that was admissible.
Thank you. I appreciate it. Anything further before we adjourn? Mr. Waters? And Mr. Harpootlian?
Nothing for the defense.
All right, perfect. Have a good evening.